Okay, good afternoon. Just for time's sake, I will probably just focus most of my discussion on the Indian Reorganization Act because to try to get all of these things into 50 minutes would be near impossible because there's a lot of nuances and so forth that would get lost in, say, you can look at some of my notes here. To really talk about the Indian Reorganization Act, we have to go back to the 1887, the General Allotment Dolls Act. And just for your information here, this is how it kind of broke down. The specific rationale behind the Dolls Act was that by allotting Indian lands to heads of households and certain individuals would teach them the idea of private property ownership. And as one public official had once said, teach them the importance of greed, because greed is the basis of civilization, and if the Indian people don't know how to be greedy and selfish, we can't become civilized like the whites around us. Now, one of the problems with this from a historical point of view is that by the 1887, the United States was pushing on Indian people this idea of the yeoman farmer, but yet within the United States, that was no longer a viable social political construct. That came more from the early 19th century under Thomas Jefferson. So here you have a policy to civilize Native people by making them consumers, making them capitalists, when even the United States, with the wider Caucasian community, were no longer embracing this idea. And one of the points was, as you see, point D, tribes lost over 90 million acres, or roughly 2/3 of the lands that they had by time. So you have 1887 to 1934. 90 million acres of Indian land were gone. That's a huge amount of land. And one of the problems with this was the Allotment Act made no exception for heirship. The idea that Indian people will still have children, they will still need to be able to provide for their families, was inconsequential to the policymakers. Enter 1928, I just put just a general overview of the Meridian Act. The Hoover Administration, you have to remember President Hoover was a Quaker, and Quakers historically had strong ties and views about Native people. Whether or not it was paternalistic or not, they still, compared to a lot of other denominations, were still very empathetic to Native people. So what President Hoover did, he commissioned the Meridian Act, and the title of the report, which was approximately 428 pages, was The Problem of Indian Administration. And in the act, it highlighted a lot of problems going on in Indian country, dealing with poverty, health issues, education. And from that act, we'll go down to this part here, which is the Indian New Deal. John Collier was the Commissioner of Indian Affairs. He had a strong credentials in being activist in the progressive movements of the early 19th century. One of the things that you have to also remember, the progressive movement was not like the modern progressivism as we know it. Progressive movement came out of the Gilded Age when you had a huge influx of immigrants from other parts of Europe who were not Western Europeans or Northern Europeans. So a lot of the people of the middle class wanted to solidify their place within the social, political, economic structures of the United States. And so they start putting forth this idea of progressivism. And John Collier was a strong advocate for this. The one anomaly that you have with him is John Collier was also a Southerner. He came from Georgia. And while he expressed this great empathy for Native people and their causes and their plight, he never passed on that same empathy towards African Americans or black people. Now, was that because he was a Southerner and that he had his own prejudice and so forth? I mean, that's going to be someone else's dissertation or thesis idea. They can go delve into that. I'm more dealing with Native policy. In 1934, John Collier introduced what was called the Indian Reorganization Act, or the Wheeler-Howard Act. And as my notes say, at a meeting in Rapid City, South Dakota on March 2nd, 1934, with delegates from all the tribes of the Northern Plains, from Montana, North Dakota, Minnesota, Nebraska, and South Dakota, Wyoming, he went to them and advocated them voting for the Indian Reorganization Act. And these were some of the promises that he made verbatim during the talk that he gave to tribal members. He said that if they adopted this format of government, they would have all of these 16 things. Now, so those of you who may have missed the presentation by Joseph Robertson, he clearly points to or alludes to the fact that a lot of times these things are not being maintained. So the gist of my discussion is, is the Indian Reorganization Act, this big seminal piece of legislation, this big piece of reform that other historians claim it is. Right now, amongst historians, there is a juxtaposition of views on it, primarily written by non-native scholars using source documents. Almost nobody goes to tribal leaders or tribal governments and asks for their input. So, and to give you a general view of how John Collier and the IRA are viewed, we can just go to a recent Senate House hearing. This, by the way, is John Collier when he was the secretary of the Indian Rights Association, a progressive rights movement that kind of launched his career into public service. So as you can see, this is the transcript from Christopher M. McMillan. He's a professor at University of Virginia who writes extensively on the Indian New Deal, and his is his testimony with regards to the Indian Reorganization Act. I'd like to draw your attention to what he says to Congress. The Indian Reorganization Act of 1934 was a monumental shift in Indian history that was a culmination of nearly 2 decades of Indian and non-Indian efforts to change how the United States managed Indian affairs. Until the passage of the IRA, the cornerstone of the policy had been the General Allotment Act of 1887. The act responsible for allowing approximately 91 million acres of land to fall out of Indian hands. So right here, you can just see he's a very well-respected historian, and he's professing this idea that the IRA was this big seminal thing. But again, my argument is, and I do it within my dissertation in the wider context of the Handbook of Indian Case Law, which was spawned by the IRA, that this is incorrect. That in fact, the IRA was really just paternalism. It was just a continuation of the assimilation policies of previous administrations. They just changed a few words here, added a few things, but unfortunately for tribes, it meant really nothing. All it really did was exchange one set of rules for another. Now, yes, it did stop allotment. It did stop the giving away of Indian lands. In some cases, especially here in South Dakota, land was sold to speculators at cents on the dollar. And the problem is the tribes were powerless to control this. One of the rationales given was that tribes were not organized, were not how would you say, we're not conscious of how to take care of their own issues. But the problem is, again, the IRA claims that it's supposed to be this reform, but in fact, one of the problems from one of the original drafts, which I have not been able to find for my dissertation purposes, is the original draft of the IRA. The original IRA was supposed to have a buyback program in which non-tribal members, Caucasians who lived within the boundaries of Indian country, of reservations, were going to be bought out and encouraged to leave the reservation. That land would be put back into a general fund of tribes. Now, a few historians have discussed this, the existence of this document. I have yet to find it. So right now, we're really just dealing in kind of hearsay and conjecture on whether or not these things existed. Now, just for time's sake, one of the documents I will be using to question and to challenge this assumption of the Indian New Deal and the IRA as being the seminal form of reform act is this letter. It was written to one of the congressional members, Burton K Wheeler, who was a congressman from Montana, I believe is a senator, who introduced this. And in it is from a tribal treasurer from the Fort DeSmet reservation. So you have the 1934 Indian Reorganization Act being passed, it being touted as this great big reform, but as you can see for yourself, this individual is writing to the senator who sponsored it, asking for his intervention and his help in dealing with, as he says, was the Wheeler-Howard disposition designed to create a dictatorship by the Indian office over the Indians? If not, why does our superintendent tell our Indian Business Committee, quote, the governing body of your tribe, unquote, that no matter what their decision on any matter may be, he, the superintendent, is the judge and has the final say? So again, John Collier says this thing is great reform. Most historians, even today, say this is a great reform. But here is a tribal official, a tribal member, asking the senator whose name is attached to this, why are we not having these rights? And again, I have to go back to some of the promises that were made to tribes. Number one, making and enforcing ordinance, electing and appointing your own officers. But here's the one where this comes in conflict with. Number four, regulating the use and disposal of property of members of the community and of the community itself. Here again, here is fact conflicting with the fiction of Indian policy. And this is one of the things that I'm finding very often is that a lot of what is being said about Indian policy is in fact dogma. It's well-meant, high-sounding rhetoric, but in fact, when it's applied to tribes, it has no discernible effect. And in fact, if anything, whoever controls the reservation, the powers are still vested in the Bureau of Indian Affairs, or at this time, the Office of Indian Affairs. And in fact, I do have the document. There is a letter between Felix Cohen and John Collier in which they discuss the IRA, and he actually asked to basically say, says something to the effect of, we can promise these tribes all these things, but we have to make sure that the real power still vests in the Commissioner of Indian Affairs. So again, I know this kind of sounds convoluted and so forth. It makes more sense in my head than it does, but that's the reason why I brought the documentation. This is the reason why I brought these things, to show you that this isn't just me making these things up. There is this pattern of behavior by the federal government to pronounce things as reform, say things as giving rights to tribes. But again, if I looked at this thing and started trying to deconstruct it, I could deconstruct it very easily. I mean, if you look at the bottom, number 16, the right that Collier promises tribes that they will have the right to sue and be sued. But if you look at the 1968 Indian Civil Rights Act, it clearly states that tribal members do not have the right to sue the tribal government, that they will not be able to obtain a writ of habeas corpus that you as a citizen could do. If you are felt that you are wronged by the federal government, you will have the opportunity to sue the federal government. Tribal members cannot do that. Another one is electing and appointing their officers. Just this last year, down in Oklahoma, the Kiowa tribe, there's this disputed election. And instead of letting the tribal court adjudicate the issue, the Court of Indian Offenses for the Southern District in Anadarko specifically tells them that we have made this determination of who the elected officials are. And it says this is the person we are going to recognize it as your elected representatives. So again, the IRA makes these grandiose promises in 1934, but the rhetoric is never played out by the facts. I'd look at the other parts of it. I think there's one on okay. There was one I mistyped it. Basically, it talked about protecting Indian rights to their own religion. The problem with that, of course, is under the United States Constitution, we as citizens have the right of freedom of religion. I believe it's the First Amendment. But it wasn't until 1978 that the United States Congress had to pass the Indian Religious Freedoms Act. So again, here is examples of 1934 making these grandiose promises to tribes. You will have these rights and so forth, but the rhetoric never matches the reality. And the reason why this is important is because the IRA is still the piece of legislation the federal government relies upon to discern its relationship with tribes. I mean, some of the other speakers have talked about what's an Indian. The IRA very loosely gives a definition of what an Indian is. Basically, it goes to person who is an enrolled member of a federally recognized tribe. Now, some historians argue that is this because they didn't want to get involved, that they didn't want sovereignty. Most people say yes. I would have to differ just because there are certain instances, other previous court cases, I think of Saldaria v. Martinez, and some other ones in which the United States government, through the federal court system, intervened and told tribes who their citizens were. But for purposes of the Indian Reorganization Act, it was more convenient for the federal authorities to kind of kick that can down the road, not be pigeonholed, because another problem that you have with it, and this was me doing my research with the Handbook of Indian Case Law, was there are a lot of people in the eastern United States who had intermarried with African Americans. So physically they look black, but in one document, Felix Cohen basically says, well, they're more black than they are Indian, so you know what, we're not going to recognize them as an Indian tribe, also because it's going to negatively impact our relationship with the state of New York. So again, you know, the tribes are supposedly having the right to determine who their citizens are, but yet the onus of even saying who is a tribe is still firmly vested in the hands of the federal government. So, you know, the overarching thesis of my really kind of haphazard presentation is the Indian Reorganization Act, which people think that is this great, wonderful thing, unfortunately isn't. It's this thing, it's still a mechanism by which the federal government can exert its power over tribes in various aspects. You know, I didn't make a copy of the letter from the Courts of Appeals. It's kind of ironic because one of the things it says is, well, we traditionally like to stay out of the business of adjudicating issues within tribes, but except for the instance in which it deals with leases, contracts, and like 4 or 5 other things. So how can you say the federal government keeps the hands off within Indian country when it has all this control over different aspects of it? I mean, I think that the number it gave was 638 contracts. Even here in South Dakota, we just had an incident a few months ago, a very grisly one over at Platte. The guy was in charge of a nonprofit, Gear Up, that got us money from the Bureau of Indian Education. If you go to the website, originally it was $11.6 million, or excuse me, $7.8 million, and now it's down to $4.3 million. But if the IRA was really about tribal sovereignty, why is the Bureau of Indian Education still giving money to the state of South Dakota? You know, Johnson and O'Malley came about Title I funding for education. It was to compensate those school districts in which there was not any tax revenue from the Indian tribes. But again, the problem is it gave money to the states, and it flew directly in face of the U.S. v. Dogma Supreme Court decision of 1887, in which one of the things it pointed out was, and this is not a direct quote, but the idea that the states are the worst enemies of tribes, and it's the U.S. government's responsibility to protect tribes from the state. So 1887, the U.S. Supreme Court says, we have a responsibility to these people. You want to push it back further, you want to go to 1790 with the Intercourse Act. You know, newly passed Constitution, and one of the first acts of Congress is to say that only Congress has the right to deal with Indian tribes in regard to trade. So again, you have all these, I could go on with all these Supreme Court cases in which the federal courts say one thing and then they do another. You know, I mean, we can even talk about the idea about treaties. Treaties were abdicated in 1881 by an act of Congress, less because the United States government didn't want to enter into treaties with Indian tribes, but more on the issue of a turf war between the Senate and the House and with the executive branch. So the other part of this thing is that there are a lot of other exterior factors involved. Unfortunately, it's a lot of moneyed interests that are involved, in my opinion, and my research kind of shows that really push these things. The tribes are given these false promises of being able to do these things. I mean, again, if you look at number 11 here, levying assessments on members and requiring labor in place of assessment. Well, if you're a lawyer, you can construe that as being able to tax people. But unlike the city of Brookings, my reservation, my tribal government cannot levy a tax against anybody. So why is it that my reservation, which was roughly 10 to 12,000 members, so comparable to some of the smaller or mid-sized cities here in South Dakota, don't have that right? If we have the IRA and it's supposed to be this great reform. I mean, part of it, I think, is just because the fix is already put in, the language is made so vague that lawyers from the government can write and construe things in whichever manner they want. I mean, if you look at number 13, to make contracts and employing attorneys, and yet there's a letter from the Court of Indian Offenses in Anadarko saying we have a say in contracts. We have a say in these 638 contracts with Indian tribes in the state of Oklahoma. So how can you say that the IRA is really reform when still tribes have to answer to the federal government on all these issues that even state governments, city governments are exempt from? This is a really big issue. I really kind of had to really pare it down. And I could probably answer questions more point by point, so I'm going to stop right here. I'll bring up any slides, whatever, to support my arguments, but if there's any questions, I'll entertain them right now.
Is it useful to think of the IRA as a transition document? The way I see it, from roughly 1890 to 1934, the reservations were essentially concentration camps, and beginning with the IRA, we start giving at least some voice to the Native peoples in the control of their lives.
It depends on your point of view. It could, in some respects, it could be seen as transition, especially for Plains tribes. But one of the problems is with the 5 tribes in Oklahoma, the Chickasaw, Cherokee, Creek, Seminoles, who had a 3-tiered form of government, but that by the early 20th century, landed interests in Oklahoma wanted to get rid of the tribes, so they passed the Curtis Act, which negated tribes. First, it undercut tribal courts, and then it did away with a complete government structure, which was based on a U.S. type model of 3-tier government. So so in 1906, the Curtis Act abrogates this organic internal political construct within the tribe, and then they go back and reinvent the will. The other thing is, a couple of tribes, I believe it was my reservation, Cheyenne River, but also Rosebud, in the, I think, 1918, 1916, wrote their own constitution. They realized that the issue of allotment was taking more lands, that there wasn't going to be land for future generations. So they, on their own volition, without John Collier, without Felix Cohen, without the IRA, without this piece of legislation, realized the utility of having a constitution, and tried on their own over a period of time create their own form of government in which to represent the interests of the entire reservation. So yeah, the standard narrative, if you want to take the IRA, it's a transitional document. But my research shows that tribes were already going in that direction, or had gone in that direction, and had they been able to do things at their own speed, we might have ameliorated some of these issues that still exist now. But this was kind of a, let's do this now, let's do it because it's the time and place, but also some of the other scholars who I've talked to about my work was that they needed to do it in a really expeditious manner because Franklin Roosevelt didn't know if he was going to be in office. And the problem is they never went back and to correct these things. I mean, World War II started, so the focus on the Indian New Deal dissipated for the greater war effort. But after the war effort, just like after World War I, there's kind of this return to normalcy mindset in people. They didn't want to deal with hard issues. They didn't want to deal with uncomfortable things. They just wanted to kind of try to resume their lives where they thought it left off. And in the aggregate, the Indian tribes paid the price because by 1953 you have the Termination Act.
Knew that the IRA was another tool for assimilation, but I can't help but think about the John Collier of the 1920s, and we sort of have this image of him as really valuing tribal cultures, and I would think that would include political culture as well. And I can't help but wonder, after his tenure as Commissioner of Indian Affairs, did he ever look back and say, oh, we really made a mistake, or we went too far in this direction, or anything like that?
No. In fact, there is one letter to Felix Cohen from an individual who tried to interview John Collier, and he kind of hinted around that John Collier did not like to talk about what he did in the past if it in any way he felt it was critical of the decisions he made. So he wasn't retrospective. He really still felt that his vision was the correct vision for Indian tribes, and it was still grounded in paternalism. And the other part of it is that his idea of Indian nations reasserting themselves was based on his experiences with the Pueblo. And again, that is a big fallacy of Indian policy, is that one size fits all. That tribes are one just humongous group that we share the same exact values and beliefs, and that's really not true. I mean, I'm studying down in Oklahoma. They sound like they're from Texas. They like same things as they are from Texas. But if you call an Oklahoman a Texan, you better get ready to throw down, or vice versa. So this artificial identity really means a lot, even though they're essentially the same people. So to think that tribes are the same way was incorrect. And I think Collier, while well-meaning as he was, unfortunately kind of saw the forest and not the trees. And he tried to do too much. And unlike the Meridian report, they included Henry Rowe Cloud, who was from the Winnebago tribe in Nebraska. Collier did not bring any Indians into the administration as advisors. And in fact, we talked about Ella Deloria a couple of times. I have a letter written in 1934. Ella Deloria wrote to John Collier, availing herself up to him, saying, I have these qualifications, I have these experiences. One of the things I deal with is the sociological problems in the Indian country, and he never responded. So so this guy is a savior of Indian country, but he never talked to an Indian.
I have a question. It seems like the tribal council form of government has been troubled from the beginning in many ways. And one thing that I heard about that was because that majority rule didn't work well on reservations, that it hadn't been the consensus kind of government. But it seems to me that maybe another reason, and I was just want to ask if another reason why tribal governments has had so many problems is because although they were set up with all these supposed powers, they didn't really have the powers.
That was part of it. Another part of it was there was kind of an unofficial litmus test to tribal political power, in that you had to be literate. So that excluded a huge branch of people who could not read and write English. And so the people who gravitated towards power after the implementation of the IRA were, some of the people back on West River call it the stay around the fort people, or the Yescas, the mixed bloods. So they, because of virtue of their education, because of their belief in the assimilation process, were automatically brought in, and they gravitate towards control within these tribal governments. And and unfortunately, the problem with that, and I'll just say very loosely with regards to my reservation, is these people look after some of their own political interest. One tribal chairman on Cheyenne River, he looks after the ranchers to the exclusion of other people. So humans are still human, and the problem is, one of the things that the criticism the tribal governments have are that they're expected to hit the ground running and perform almost in a flawless manner without any bumps in the road. I'm teaching U.S. history, and early U.S. history is full of bumps in the road. You have the Articles of Confederation, you have the fight over the U.S. Constitution, you have the issue of slavery. You have all of these things that over time had to be dealt with by the U.S. government as it became a democracy. And yet tribes within 1 generation, 2 generations were expected to adopt a foreign form of government, to go from a consensus form of adjudicating issues or resolving political issues into a majority rules and perform almost flawlessly. And by not being able to do that, that lent credence to their critics. So again, it's kind of almost like the tribes were set up for failure.
I'm just kind of curious because you've pointed out the flaws and the faults that the state's government and the federal government has, and what the mistakes in the past have been. What could they do going forward to kind of almost change back time and fix what they've done?
You know, that's a good question, because even with the IRA, one of Collier's original ideas was to create, to get away from allotments completely and have the land set aside communally. The problem that they had were individual tribal members who were raised, who had gone through the school systems and attached a lot of personal value to property. So really, it's going to have, for something to happen now, it's going to take a long systemic change on all parts and people being willing to compromise. But unfortunately, in this, you know, political atmosphere we have, it's one side or the other. There is really very little wiggle room for compromise or long discussion, and we unfortunately live in a society with quick fixes. So as far as resolutions, I guess I'm just trying to point out the flaws, and I'm hoping that there's someone out there who's smarter than me, and whoever he or she is, that they can build upon my scholarship and start that ball rolling. I'm just diagnosing the problem. I'm not the specialist. I'm the generalist here. So, but you know, if you want to try it, hey, go for it.
When I was at Arizona, one of the things we talked about were the constitutions that were brought by the IRA government. Can you talk about that? And also, I don't know if you're familiar with the Native Nations Institute in Arizona, in Tucson, and how part of their process of nation building is actually reform through looking at these constitutions that the IRA brought, and then going back to original tribal ways of governing themselves. So they basically try to throw out these IRA constitutions and then go back to the original forms of government. And that's through the Native Nations Institute in Arizona. And that's one way, I guess, of solving this problem.
Yeah, the problem with that, unfortunately, is I had an aunt who worked for the BIA. She's from my dad's family in Oklahoma, and her job was to approve tribal constitutions. So the IRA, they've already created the mechanism. If you read the whole, and I'm not going to, guys, bore you with a government document, because it gets down to what is. It's a minutia of trying to figure out what everything is, but the government already gives itself that power to have a final say. Now there are people who do challenge it. About 4 or 5 years ago, the Seneca tribe went to their clan mothers, their traditional form of government, and they complained to her about a tribal official who was elected, and they sought removal, and he was removed when all the clan mothers deliberated about it and removed him, and the BIA did agree to that, but also they're under a kind of a watered down version of the IRA, just like the Oklahoma tribes aren't really part of the IRA, with the exception of the Osage tribe. The Oklahoma tribes are under the ironically titled Oklahoma Indian Welfare Act, and which gives the state of Oklahoma more say in tribal issues. Like, for instance, there was a contested election on the Cheyenne Arapaho tribe, and what the state government, Supreme Court, did was it froze its assets. That would never occur here in South Dakota or in other parts of the country. So again, and that's the problem, is even though there are these legal differences between tribes, that it's not a one-size-fits-all, and the IRA clearly points that out, and so does the Handbook of Federal Indian Case Law. The governors, the state politicians, they try to use whatever means possible, because the cynic in me says they count on the fact that nobody wants to read the Handbook Indian Case Law. I mean, it's 500-600 pages. So, or that Indians themselves are ignorant of these things. You know, and but I agree that tribal forms of government might be a possibility. Now, there's other thorny issues, because I have an aunt in Oklahoma who, in a fit of anger, said we should go back to the clan system for Cherokee Nation, and if you don't have a clan designation, you're not a Cherokee member. Now, there are a lot of white people, and they are white. They're not Indian by blood. They're Indian by act of Congress. Their ancestors were whites who married into the tribe, but their spouses died, or they were recognized by a legal act by the tribe. But they are entitled to the full citizenship of Cherokee Nation, and that's the same thing with some of the other tribes. So if you see blonde-haired, blue-eyed people from Oklahoma saying they're tribal members while they're citizens, they're not Indian. But they're not going to idly stand by and lose all the services and entitlements that they get from the tribe. They're not going to give up those scholarships. They're not going to give up those perks that do come with being an Indian, that somehow people always say we have up north, but I don't see it, because it was a Veterans Administration who gave me my money to go to school. It wasn't, and it was, because I hurt my back in the military.
Wouldn't you have difficulty going back to a traditional form of government in this sense? One, again, the point I made earlier about the 1890s, 1934, most of the knowledge of how traditional government worked was lost during that period. And then the second thing is that, at least I don't know all the different tribes, but with regard to at least the Lakota, and Dakota, most of their traditional tribal government was a government for about a village of about 100 people, where now we're talking about a government for 14,000 people, on some of the reservations, and that's going to have to be run a whole lot different than a little village government.
Yes and no. If you look at Creek Nation in Oklahoma, they have a lot of townships which ethnically, culturally, linguistically, they're Creek, and they're part of Creek Nation, but they also have an extra designation, a political designation for their each towns, because the Creeks are more of a confederation than a huge homogeneous group. And that's a lot of issues with a lot of tribes. I mean, why did the Lakota, and Dakota not ever be able to come together to resist westward expansion? Is because we are more of a confederacy, and we kind of, unfortunately, looked after our own immediate interest. I think it is possible. I know, out in the West River, there still are the traditional chiefs. There are still those families who have hereditary, there are hereditary political leaders. But again, some of the other people present saying you still had the opportunity to pick who you followed. I mean, Sitting Bull was not a chief. Crazy Horse was not a chief. But people gravitated towards them because of what they stood for and what they fought for. When a lot of the other chiefs were happy to go to the reservations and, as Sitting Bull said, become a slave to a piece of fat bacon and hardtack, these guys still fought. So, and that's the other thing is, I don't understand why Indian people we're always kept in a position of stasis, that we are somehow incapable of evolving. If you look at the 5 tribes, they saw the writing on the wall when they were east of the Mississippi. So we have to cut our hair, we have to divvy up the land. The difference between them and white government was it was still owned communally. And I would argue, and I will in my dissertation, the idea that the reason why the Curtis Act isn't in the Handbook of Case Law, other than basically a footnote, is that the 5 tribes allowed you to work land without title to it, without fee simple title to it, like you do in white society. And it was a functioning apparatus. There was not acrimony like we do have in white courts over who owns what land and who has a right of way and easement and so forth. So the examples of Native people being able to transition into, if you want to call it a more modern construct of economic structure, it is possible. There are examples of it. But again, Collier and the IRA and the Handbook, they all were kind of pushing us to the nth power. They never really made a concerted effort to look at other alternatives as they existed. And that in lies one of the problems is, I would argue that John Collier was as much a believer in American exceptionalism as the most conservative people of that time. That the American way is the only reasonable way of developing something, when in fact, it's not without its own problems. He was accused of being a communist. He was accused of being a paganist. He was accused of being an atheist because he deigned to say Indians should be able to practice their ceremonial life. I mean, that goes against, the Constitution. And even though the IRA was supposed to guarantee religious rights for Indian people, it wasn't until 1978 that another act of Congress had to be passed so that I could go sweat, or I could use a pipe, or I could go Sundance. The other thing of the point I like to bring out, and I don't know how I'm going to use it in my dissertation, but the Allotment Act saying we have to be allotted and we have to have private property. Well, then how do you explain, the Amish community, the Hutterites, who own land communally, who live separately and distinctly from mainstream society? They don't send their kids to public schools. Some of them don't speak English, and yet they're allowed to exist within the wider American society and are not deemed a threat, but somehow Indian people living communally, minding their own business, somehow were. And so we have to pass legislation after legislation. We break it, we try to fix it, we break it some more. And the IRA, again, it was well-meaning. I'm not trying to say John Collier was a hateful, racist person. Well, maybe for African Americans he might have been, but and very much being a product of his time, but this wasn't reform. This was just assimilation by another means. Well, yeah. I would argue that, again, we'll go back to the US v. Cogma law, or Supreme Court ruling. It's the federal government's responsibility to protect Indian tribes. We go to the Commerce Clause. We go to various Supreme Court cases in which the federal government gives itself this authority to deal with Indians, says the state should be excluded, but then how do we explain, the Indian Gaming Regulatory Act, in which tribes have to negotiate compacts with the state and have to give states a portion of their gaming revenue, when the Constitution clearly says that Indians are not supposed to be taxed. How about South Dakota with right now violating the Indian Child Welfare Act? If this thing is so great, then why are tribes still fighting for their rights? Why are they trying to fight for the custody of their children?
Unless someone else has a question, I was going to pose one for you. I guess for me, and perhaps it happens to a lot of us in America because of the way that history is taught through individuals and so forth, but it seems probably a fair question, the idea of vilifying Collier versus whoever we look at in history is probably bringing with them a bag of dirty racism. So when we look at this issue or this problem, is it a challenge for you as you're doing this research to try to move away from what people will do and gravitate towards a simplistic vilifying one person, whether it's Cohen or Collier? Somebody's going to take the fall, just like what happened in Pierre recently. But this idea of how do you write in such a way where you're identifying this larger issue, which is more policy driven, is that a challenge for you as you do this research?
It's an extreme challenge. When I first started doing my dissertation, I was out to get Cohen. I was going to stick it to that guy and show how stupid he was and blah, 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 blah. And then I saw the source documents at the Belknap Library at Yale and started reading these things and realizing that he knew his own limitations. He knew that he was an extremely brilliant Jewish kid from New York City who got his master's, his PhD, and his law degree all before he was 31 years old, who overcame anti-Semitism. The problem with Cohen was he misapplied his experiences, his anti-Semitism experiences growing up in New York, and put them on Native people. He had the best of intentions, and he clearly, in these internal documents, but it's one of these things where the powers that be hijacked the image of Cohen. And then scholars, I argue, is that it's the rule of threes. If you see something cited 3 times in a journal article or a book, then my God, it must be true. You know, I'm a lot of really knowledgeable people. I am showing that they didn't exercise due diligence and research it like I did. And in fact, there's one article by a woman named Jill E. Martin. She's the head of the legal studies department at Quinnipiac University in Connecticut. She wrote a journal article that's in the 2005 and 2012 versions of the Handbook. And in it, she gives this rah-rah speech that Cohen supposedly gave. Well, I saw the handwritten notes, and the part that she emphasizes in her journal article that's now published and now has its own validity, it was written in pencil and he scratched through it. So he changed his mind writing that. But she took it. She's a lawyer by training, so I'm sure I have a year of law school under my belt, so I know how we lawyers do it. You cherry pick and you make the evidence fit your argument. And that's kind of the problem, is that yes, but hopefully when some of you who plan on going to grad school and doing research, you look at the source documents, you follow the intellectual bread trail and then hopefully you have maturity and a peace of mind to try to look at this thing wholly and come to a better understanding of it. I am extremely empathetic to Cohen. I mean, for the IRA, Jewish kid, never met an Indian. He had 7 months to write this legislation. The Meridian report had roughly the same time, but it had a staff of 9 people, and it had a native person who was a longtime employee of the Office of Indian Affairs. So again, my original thing is, Cohen, you're going to suffer. I'm going to make you pay, but wait, I worked in the U.S. Senate for Senator Tom Daschle, and my personal experiences showed that you don't get ahead by telling your boss no. And some of you guys who have jobs, you know that. You don't tick off the boss, otherwise you're going to hit the road. Cohen was no different at this time. He was tasked with these things. He did the best job he could. My feeling is he expected other people to be just as diligent, just as thoughtful as he was, and unfortunately that didn't come to pass. Other exterior factors and then just human nature kind of clouded it and made this thing more convoluted. And instead of being this great reform with all this potential, instead just became something to beat Indian tribes over the head with, and then to create the acrimony and misunderstanding. So I posed a question to my aunt once. I told her, I said, well, if Indian and whites miraculously stop hating each other and pointing fingers at each other today, who would benefit and who would and who wouldn't? I mean, it's a bigger philosophical question, but you really have to kind of ask these questions about these things. Be inquisitive about the evidence. If you don't believe me, read Francis Perka, read some of these other books, and then draw your own conclusions, but use the facts too. Because we all have our internal prejudices. Felix Cohen and John Collier thought they were doing something good. Well, when you don't talk to the people you're supposedly supposed to be helping, how much good are you really going to expect to come out of these things?